Okay, so I'm going to do a brief overview of the FIRAC method, and then I'm going to go ahead and give you guys an example piece by piece. So you're not confused, and so we can do this together. I'm going to give you um, a case that you can look up on your own, and you can see how I broke it down. Okay, so we have a memo from a, let me see, where is it? So we have a memo template that they gave us from school. Um, you're going to have to know how to do this if you're in law school. And I'm going to simplify it as much as I can. So here we go. The facts of the case is the background story. That means what happened. In the facts, they also want to know, first of all, they want the chronological order of the things that happened on the day that this situation happened. For example, if someone fell on ice, it would be the day that that happened. So you're gonna want to get that date, and you're gonna want to start with on such and such a date, blah 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 happened. Then this happened. Then this happened. Okay, they want to know also in the case what the clients are claiming. So, in some cases, it would be, like such and such is claiming that his Fourth Amendment right was violated. Okay, so that would be the claim. Also, an important thing that they want to know in the facts is what are the parties seeking. So we're going to get that information. So what the party is seeking is going to be either the monetary damages, how much money are they going to sue for, or what do they want? Do they just want money? Do they want some kind of other compensation? Do they want do they want the courts to order somebody to stop doing something? In the case of like stop and desist, for example, if somebody's using your name that you trademarked and they're using it, I don't know, on the internet, on television, and you coined the name and you trademarked it, you're going to send them a cease and desist. So that would be an example of you seeking the court to stop doing something. The court to order the other party to stop doing something. Okay. Also, what they want to know in the facts are only the relevant facts. So let's say that somebody slipped and fell, okay, and they tell you in the narrative in the case that this person just got back from Hawaii. If they slipped in front of Walmart, it has no relevant. It's not relevant that they went to wherever before they got home and slipped on the ice. Or if they give you any other information that doesn't pertain to the case. So, in my opinion, you're going to want to go through the whole case and highlight the narratives. So you're going to want the narratives from both parties. I would highlight both of those. And then you're going to start to type or write, whatever you like to do. If you like to write it down first, I mean, that's your prerogative. Or you can start typing. It depends on you, really. So you're going to want to highlight the narrative of both parties, which they should give you both. You're going to want to write down the date because you're going to say, on such and such a date, such and such happened to such and such. And as a result of that, such and such has had to blah, blah, blah. I don't know. Like go to the hospital, have surgery on their leg, or in the case of slipping in front of Walmart, they would have to basically, you're going to want to tell in a chronological order what happened on that day. And in that fact section, you're only going to put down that. You're going to put down the background story, what happened in chronological order. You're going to start with the date. In my opinion, to find the facts, you're going to want to go through the whole case, read it or skim it, depending on, how much information you can pick up from skimming. I mean, I usually read the whole thing at least one time and try to look up all the words that I don't understand, because you're going to find out, unless you've already been in the law field, that there is a lot of terms that you're not going to understand. And if you don't look those terms up, you're not going to really fully understand the case. But if you want to just skim through it and highlight the narratives, that's going to be what your facts are. What happened that day in chronological order according to the relevant facts of the case. Okay, how do we know what's relevant? Well, we don't yet, because we don't know what the issue is or anything else yet. So just do that. Do a rough draft of the facts, the chronological order on the date, and what are the clients claiming, okay, which I just went through. In this case, let's see, the client might be claiming, let's see, in this case, St. John claims that his Fourth Amendment rights were violated. He's also claiming a false arrest and tortious battery. Tortious battery. Now, if you don't know what that is, again, you're going to want to look that up. We can do a whole video on terms also, if you guys think that would help you. So that's what they're claiming. And the third thing about the facts is, what are the parties seeking? So in this case, St. John is seeking a conviction of the officer that violated his Fourth Amendment rights, falsely arrested him, and battered him. Okay? Just so you guys know, because the word tort means that the party is seeking some kind of monetary compensation for what happened to them. Okay? So that's the facts of the case. All right. So that's the F, the facts. The I is the issue. Okay. It's very ambiguous the way they lay this out. So I'm going to break it down and try to make it easy as I can. So what is the issue? The issue, they usually say, is whether when, okay? So whether or not this person's Fourth Amendment rights were violated. Were they violated? Okay, that's the whole issue. Also, on top of that, it's the claims of battery and false arrest against the police officer. So in this situation, I put, were St. John Fourth Amendment rights violated? Was there reasonable suspicion of a crime for the police to seize and escort St. John out of the theater? Is St. John's claims of battery and false arrest valid? Does the officer qualify for immunity? Okay, that's 5 different questions. Depending on your professor, they might want you to just pick one, in which case you're going to pick the most valid one. I know it sucks because it's not going to cover everything. But my main issue in this case was the question, which the issue is a question, was St. John's Fourth Amendment rights violated? Okay, so that is the issue. Also, part of the issue is what was granted and denied as far as the courts. So for the issue, you would also say something like, the summary judgment filed by plaintiff was granted in part and denied in part. Also, the summary judgment filed by the defendant was also granted in part and denied in part. So you're going to want to write in the issue what the summary judgment is. What was the, not the summary judgment. What was the, what did the, I'm sorry, I'm trying to break this down for you guys really easy. Okay, what was filed by each party and what, as a result, was granted or denied or remanded, or there's a lot of things that could have happened. Okay, so I hope that makes sense. So we're going to go on to the rule. In this example, the rule of law was the Fourth Amendment. So I just put rule. Okay, I'm going to show you a little bit. And I'm going to try to flip this so it's not backwards when you look at the words. But, so we're going to go to the rule, which is the third thing in the FIRAC. So we're going to do Fourth Amendment. That is the rule. So all you have to do is look up what does the Fourth Amendment say. Okay, the Fourth Amendment says it is the right of people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures, not to be violated, and no warrants issued but probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, that's a lot of words. So in my case, I usually write down exactly what it says in the law. You have to. That is the reason for the rule. What is the rule that's been that's being debated in this case? Okay, so that's what the rule is. You're just going to put down what the rule is, the law that you found that pertains to this case, and then you're going to look it up. I say Google everything. I mean, if your teacher doesn't want you to do that, I don't know, because it's really hard to find laws otherwise, in my opinion. Google is going to give you an accurate, usually you can go to findlaw.com, will come up under Google, or some kind of Cornell comes up, Cornell law comes up. But make sure it's a valid source. Okay, so that's it for the rule. The rule is pretty easy if you know what the rule is. Let's see. Okay, so after the rule is the analysis. In the analysis, you're going to ask yourself, how did the court arrive at this conclusion? And then you're going to say, what was the reasoning? Okay, so also the third question for analysis is going to be, how do the facts apply to the rule of law? Okay, I'm going to have to look this up.